Hello, this is Heather Rosing from U.S. Law member firm Kleindienst PC. I'm here today to talk about mandatory legal malpractice insurance and the trends in this area. So I was involved in something called the State Bar of California's Mandatory Insurance Working Group. California, with approximately 200,000 active licensed attorneys, would we have a fund model where the state of California or the State Bar would set up a fund? Or would we just have an open market model where people would go out and buy insurance on the market? Given the enormity of our membership, we determined that the only thing that would be feasible for California if we were to do this would be the open market model. We also looked at what the appropriate limit would be. We surveyed all the states, including the 2 states that have successfully definitively implemented mandatory legal malpractice insurance, which is Oregon and Idaho, and determined that if we were to do it, the most likely limit that we would recommend would be $100,000 per claim and $300,000 in the aggregate. We also looked at what people thought about this. The majority of attorneys were opposed to it, at least the people that we surveyed. But keep in mind, pretty much every firm that we saw in California, and I think this is true across the country, with over 10 attorneys in that firm already had malpractice insurance. We also tried to survey the people who are the clients or the potential clients. We reached out to consumer groups. But what we learned is that people believed that mandatory malpractice insurance was in place in California, so that was an eye-opener. We really looked at this through a public protection lens. And we also looked at it through the lens of access to justice. If you were to mandate malpractice insurance, and we know it impacts small firm solo practitioners, and many of them may do pro bono or low bono work at a lower rate, or would the rates go up for the population perhaps that most needs legal services? So how does it impact access to justice in California? And at the end of the day, we concluded that we didn't have quite enough data to understand all of the issues and make a recommendation, but we determined that the State Bar needed to collect more precise data about who carried it, who didn't, why, and so that process and that dialogue is still going on in California. Many states have been in active dialogue for decades and currently about the possible imposition of mandatory malpractice insurance. Georgia and Washington State are in active discussions. It's very interesting to watch the landscape out there. If you are a member of the ABA, for about 15 years I've been leading the ABA Roundtable on State Bar liability issues. And for that whole time, 15 years, we've been talking not only about mandatory malpractice insurance, but what other measures short of mandatory malpractice insurance states take in order to ensure public protection. The most common one is a disclosure model. The ABA has a great chart on this, and the chart will tell you what states require that it be disclosed, perhaps in an engagement letter, what states perhaps require it to be disclosed to the Bar Association or the regulatory agency. Some states require that it be posted on the website so that the consumer, the potential clients, can look it up to see if you're insured before they hire you. The other model is PMBR, and Illinois and other states have successfully adopted this. This is proactive management-based regulation. And the gist of it is that you, the state, don't mandate malpractice insurance, but you have programs in place where small firms, solo practitioners in particular, people who don't carry malpractice insurance, are required to either take a series of courses or undergo a self-assessment to make sure your law office is running in a way that minimizes the possibility of malpractice. So it teaches you a whole bunch of topics and tips to protect the clients and, frankly, to protect yourself, thereby hopefully reducing the instances of malpractice. So PMBR was debated in California as an alternative to mandatory malpractice insurance. There's a lot of other creative ideas out there beyond the disclosures and the PMBR. These are continuing to be discussed, but I think you will see that more and more states will be seriously considering this issue, and more states will be adopting a mandatory malpractice insurance model. And my guess is that the larger states won't be able to consider a fund model, but will be looking at an open market model where you can buy it from who you want so long as you verify or certified with the regulatory agency that you carry the insurance. It's a changing landscape with an enhanced focus on public protection. So let me know if I can get you more reading materials on this, and have a great rest of your time at this virtual U.S. Law Conference.